We just filed our response to the Department of Justice in our One Big Beautiful lawsuit against the ATF in the National Firearms Act registration requirements. We're taking the fight to the DOJ and calling them out on all of their tyrannical BS. Today, I'll break down our response filing, and we'll talk about where the fight is headed, the abolishment of the NFA entirely. Hi, I'm Ben, and you're watching the Minuteman Moment. Gun Owners of America is fighting for your rights every day, all over the United States. But don't just take it from me, listen to what these guys have to say.
What I appreciate about the Gun Owners of America Association is they're picking fights out in the public sphere. You got a bunch of lawmakers infringing upon our Second Amendment rights, and GOA is out there with a shiv in a street fight ready to protect our Second Amendment rights, where everybody else is just talking about it. Or we're taking to social media, which does have a value. They're out making lawsuits and making trouble for tyrannical lawmakers. And so I respect that. That's an organization I can get behind and respect and finance and promote. So way to go, GOA.
I like that GOA is very hands-on. There's a lot of gun groups that like to talk a big game, a lot of very big gun groups that like to talk a big game, but GOA is actually there on the ground, and they're a no-compromise gun group that's actually fighting for our rights instead of talking about fighting for our rights.
What do I like about GOA? Well, number one, they're no compromise, which I absolutely love. That is my position as well. I believe Americans should have all of their gun rights. We should have no restrictions on the arms that we have, and GOA agrees with that, so I back them all the way.
Consider signing up and becoming a member today at gunowners.org. Now back to the video. On July 4th, 2025, President Trump signed the One Big Beautiful Bill Act into law. Thanks to the One Big Beautiful Bill Act, the $200 tax on certain items regulated by the National Firearms Act, specifically suppressors and short-barreled firearms, was reduced to $0. But thanks to an unelected bureaucrat, the Senate parliamentarian, the registration requirements of the NFA remained. Obviously, we at GOA couldn't stand for that and filed a lawsuit against the ATF. We're calling it the One Big Beautiful lawsuit. And after months of waiting, the Department of Justice filed a brief opposing our case. This came as a disappointment, because not only does the Department of Justice refer to itself as the most pro-Second Amendment DOJ in history, there are some pretty pro-gun people working at the department. Not only that, but the DOJ could choose, if they wanted to not defend the law at all. We've seen this in DC, where U.S. Attorney Jean Pirro has filed in court the U.S. government believes that magazine capacity restrictions are unconstitutional. But the reality is, the DOJ has chosen to defend one of the most egregious gun control laws in U.S. history. In their brief, the DOJ used anti-gun talking points, calling the NFA regulated firearms weapons of war and particularly susceptible to criminal misuse. These statements seem like they were pulled straight from a Biden-era legal filing. Instead, we've been told they were given the okay by Attorney General Pam Bondi. Additionally, the DOJ claimed in their brief that the registration requirements for the National Firearms Act were completely constitutional, regardless of the fact that the tax had been reduced to $0. This means that the DOJ has taken the stance that if you don't register your firearm with the ATF, you'll be put into jail for up to 10 years for not showing proof that you paid or didn't pay a $0 tax. In fact, 2 separate Supreme Court cases confirmed that the NFA was essentially a system for registering proof of tax payments on certain firearms, not regulating the firearms themselves. And now that this tax has been reduced to 0, the original purpose of that registration no longer exists. With that in mind, today we filed our response to the department's truly anti-gun brief. In our response, we outlined 3 reasons that the DOJ is wrong in their arguments and why registration of untaxed firearms violates the Second Amendment. First, we argue that short-barreled firearms are in common use, pointing out the DOJ's reliance on the Miller and Heller cases fails. But what does that mean? Well, U.S. v. Miller and the District of Columbia versus Heller are both landmark Second Amendment cases decided by the Supreme Court. The theory from the DOJ is that the U.S. versus Miller case upheld the National Firearms Act regulation of short-barreled shotguns, and the Heller case did not overturn the Miller case. The DOJ extends this argument from Miller to also encompass short-barreled rifles as well, saying that SBRs and SBSs are materially indistinguishable. But here's what the Department of Justice forgot to mention with their cherry-picked evidence. U.S. versus Miller's ruling had expressly stated limitations. Here's what the Supreme Court had to say in that case. It is not within judicial notice that this weapon, a short-barreled shotgun, is any part of the ordinary military equipment or its use contributes to the common defense. The court said it couldn't assume a short-barreled shotgun was military equipment because the defense never showed up to provide any evidence. And later, when DC versus Heller was decided, the Supreme Court cautioned lower courts on Miller's limited scope, warning that it is particularly wrong-headed to read Miller for more than what it said. Instead, the DOJ reads the Miller decision broadly to lump SBRs and SBSs together in an attempt to dismiss our case. In addition, the DOJ completely ignores more recent cases like New York State Rifle Pistol Association versus Bruin. In the Bruin case, the Supreme Court explained that we use history to determine what modern arms are protected by the Second Amendment. That means that judicial opinions about a weapon's purported dangerousness or similarities to other dangerous weapons are irrelevant to whether a weapon is protected by the Second Amendment. The Bruin decision also explained that even a historical tradition for regulating a particular weapon provides no justification for laws restricting that weapon if it is unquestionably in common use today. But DOJ doesn't even acknowledge the modern popularity of SBRs and SPSs, nor did they acknowledge the common use standard anywhere in their brief. That's not accidental. The Department of Justice knows that their attempt to preserve the National Firearms Act is an act of bureaucratic defense. By losing the registration requirements of the NFA, it's a lot harder for ATF to harass law-abiding gun owners. Also, the government would be giving up power, something that no government is ever happy to do. But the truth is that suppressors and short-barrel firearms are in common use. In fact, in our brief, we explain that there are 3,536,623 suppressors, 870,286 short-barreled rifles, 165,180 short-barreled shotguns, and 88,149 AOWs, or any other weapons, registered with the NFA as of 2024. And the popularity of these items increases every single year, with almost exponential growth. In the case of Caetano v. Massachusetts, the Supreme Court found that a weapon was in common use with nearly 200,000 in circulation. And in the case of Maloney v. Singas, a weapon was found to be in common use with 64,890 in circulation. We're not aware of any case finding that 3.5 million examples of something is not considered in common use. Next, we argue that the Fifth Circuit's recent Peterson decision does not foreclose the protection of suppressors. Translated from legalese, the Department of Justice is relying on a very recent decision in the case U.S. v. Peterson to dismiss our arguments as to why the registration requirements of the NFA should be removed from suppressors. In the case U.S. v. Peterson, the Fifth Circuit Court of Appeals rejected a challenge to the National Firearms Act registration of suppressors. But, like the Supreme Court said in the Miller decision, they only wrote that Peterson has failed to develop any argument or record to show that the NFA is unconstitutional as applied to him. This is notable because the Fifth Circuit didn't rule in a way that could stop someone else from challenging the NFA in the future. However, the Peterson case and the Fifth Circuit decision labeled the NFA as presumptively constitutional shall issue regime. That means that in order to mount a successful challenge to the NFA under Peterson, a challenger must show that the NFA has been put towards abusive ends through exorbitant fees or lengthy wait times in processing licensees' applications. Anyone who knows anything about the National Firearms Act has heard of the dreaded wait times and the exorbitant fees imposed on those attempting to access their Second Amendment rights. Horror stories of NFA approvals taking nearly 2 years were common just a few years ago. And while the ATF has worked to speed up wait times thanks to pressure from GOA allies in Congress, it's not perfect. Regardless, the Peterson case never mentioned the one thing that would have likely made the point the best. Suppressors are in common use and therefore protected by the Second Amendment. Finally, we argue that the Department of Justice completely failed to bear their historical burden. While the DOJ attempted to justify the National Firearms Act historically, at no point did they offer a single historical analog. Instead, the DOJ references examples, those being a law review article and a few court opinions. The Department of Justice claims that because of these examples, the NFA comports with the Second Amendment. But the truth is, modern journal articles and recent case citations do not establish a historical tradition of firearms regulation dating back to the founding of the United States. This is the standard that Bruin requires. Otherwise, a provision is unconstitutional. In fact, actual examples of historical firearm regulations are needed. The Department of Justice did not provide any. That should be a clear-cut example of their inability to defend the constitutionality of the NFA. The rest of the department's argument rely on anti-gun talking points, whether a firearm is concealable or desired for criminal purpose or useful in war. None of these examples demonstrate that the National Firearms Act is constitutional under the Second Amendment. In reality, that logic would justify further restrictions to every handgun, the most concealable and most criminally misused firearms of all time. It would mean that the people's Second Amendment rights rise and fall on the actions of criminals. We're asking the court to reject the DOJ's terrible logic and side with us against the National Firearms Act, which is clearly the right choice. We'll keep you updated as the case moves forward. Now, thanks for watching. Be sure to like, comment, and subscribe to stay up to date with GOA's latest fights for your rights.